Now I request Dr. Sarfaraz Ahmed Khan, sir, to wind up the session with his concluding remarks. Please, sir.
Okay, good evening, everyone. So I have two jobs. One, to give some kinds of concluding remark of the two technical sessions which happened now, and as well as to present the thing which I supposed to do as per schedule. So the so far concluding one is concerned. Thanks all the panelists for making excellent presentation. So you already here, so we know the time, paucities of time. I'll go directly to the thing which I want to present, and the title which I given of my presentation was the BNSS Bharatiya Nagarik Suraksha Sanhita, what we have failed to achieve from this law. Now, let we clarify first. From morning we are hearing that we have to get rid of this British hangover, colonial hangover. CRPC was 1973 law. It was more Indian than the BNSS. Why so? Because the amount of time deliberated on the passing of CRPC was far, far, far greater than the time taken for the passing of BNSS or consultation of BNSS. So the Indian representative, the amount of time they devoted in CRPC was far wider. So it is more Indians, they are able to deliberate, they can talk about it. So it's not the colonial hangover. CRPC was not at a way it was a colonial hangover. We have passed the law in 1973. In fact, when we see the legislation on procedural law of the different part of the world, they all use the words criminal procedure. For example, Criminal Procedure Act 1977, South Africa. Criminal Procedure Rules 2020, United Kingdom. Federal Rules of Criminal Procedure, USA. Criminal Procedure Act 1986, Australia. Criminal Proceeding Rules, Canada. The Criminal Procedure Ordinance, Hong Kong. So that throughout the world, when they divide the procedural law and substantive law, they act objective clearly says a criminal procedure. And by changing that Nagarik Suraksha Sanhita, it does not make any sense. Neither it is for Nagarik Suraksha, nor it is for the accused Suraksha. So it's 95% almost same what was in the CRPC. Some places they have made change. But what they have not done, or what they have done injustice, I wanted to talk to on those points, few points. First of all, what they have not able to achieve is ensuring in the real sense right to speedy trial. We remember Supreme Court consistently says right to speedy trial is a fundamental right. You have legal aid cases like Husna Ara Khatun, other cases where this is right to speedy trial. But more importantly, there was a Supreme Court judgment, specifically A.R. Antule, 5 judges bench decision. It says right to speedy trial is a fundamental right under Article 21. Common Cause 1, speedy trial is a fundamental right. Common Cause 2, speedy trial is a fundamental right. But none of those laws dare to fix the time limit within which we complete the trial. So one of the panelists was saying that the time we taken for completing the trial in criminal cases is the same thing today also. So it takes 20 years, 25 years, but there should be some time limit in which the trial can be completed. What happened in 1999, there was a case called Rajdev Sharma, and in Rajdev Sharma first case, the division bench of Supreme Court was dare to fix a time limit, and they says criminal cases must have a time limit within which you should finish. If you don't finish within 3 years period, the case will go to next step. CBI went in appeal. In Rajdev Sharma 2, Supreme Court clarified that it is a delay because of the accused. Those time need to be expunged, and then the time will be calculated 3 years period. So from 1999 and 2000 it was reported, second was 2000. From that point of time till 2009, Rajdev Sharma was rule. But the time comes in the year 2009, when there was another Supreme Court judgment, it's called P. Ramachandra Rao. And P. Ramachandra Rao, Supreme Court did not go into merit. Had they gone into merit, there's a different questions. The P. Ramachandra Rao went on technical issues. And the views was that A.R. Antule, 5 judges, has not dared to fix the time limit. Common cause, 5 judges, has not dared to fix the time limit. How can you division bench fix the time limit? So on technical ground, P. Ramachandra Rao has set aside Raju Sharma 1, Raju Sharma 2. Now issue comes, because of the technical ground it was set aside, when we are coming up with a new law, it was an opportunity for us, if the right to speedy trial is really makes sense, they must have come with a time limit. There are some places they have fixed the time limit, charge can be in 60 days, after argument 45 days, discharge application 60 days. So you will find in several places in the BNSS, they have fixed sporadic some time limit, but that does not going to make change. You must have, if the right to speedy trial is a fundamental right, you must have a framework within which the trial can be completed. So this law failed there. Second failure of this law, or what I think the worst thing which this law has done, I normally say is the worst disservice to the criminal justice system, what this law has done is denying to access to justice or weakening the access to justice of the citizen of this country. How they did it, let me explain. I believe many of you have done already CRPC. In the CRPC, the criminal cases start with 3 processes. First process to start criminal cases is registration of FIR. So in the old law, it was section 154 CRPC. In the new law, it became 173 BNSS. The second process is, when FIR is not registered, someone can go to the court and court can direct the magistrate to register under 156 clause 3. So that become under the new law 175 clause 3. The third process to begin criminal case is filing a complaint. It was 200 CRPC earlier, now become 223 of BNSS. Now what the disservice this law has done to the common people? In the FIR, they added second clause where they says that in cases where punishment is up to 7 years, police, instead of registering FIR, they can do preliminary inquiry. For what purpose? Preliminary inquiry for the purpose of ascertainment of whether there is a prima facie case exists or not. Now, where we used the prima facie case earlier, traditionally, the word prima facie case has been used in respect of determination done by the magistrate, by the court. So when court frame the charge, it is on the basis of prima facie case. When court take cognizance on the basis of prima facie case, the kinds of a determination which judicial magistrate used to do, now we are expecting that police, instead of registering FIR, they will determine in cases where the punishment is 7 years, that okay, without FIR, they will do prima facie cases there or not. Sometime argument is raised that okay, Supreme Court in Lalita Kumari case says of the preliminary inquiry. But where the distinctions? The Lalita Kumari, when it says prima facie case, it says about the preliminary inquiry, it says preliminary inquiry to determine whether there is a cognizable offense or not. This is not prima facie case. So the only margin which available according to Lalita Kumari with the police was that police must be satisfied that there is a cognizable offense, but if police is not satisfied about the cognizability, then they can do preliminary inquiry and then once satisfied, they registered FIR, not on the merit, whether the statement reveal cognizable offense or not. Now in village area where poor citizen does not even dare to visit the police stations, we want them to move from one after another to the police station to register FIR, and then police can say we are doing preliminary inquiry. Which police? You remember after independence from beginning till now, police commission says police don't register FIR. Even police commission's reports are the reason for which the police don't register FIR. Police commission says extraneous influences and corruption that operate on the system and disinclination of the staff to take on additional load of investigations work. Is a police commissioner is saying, not outsider, that police don't register FIR. Malimat committee says police don't register FIR. Law Commission says police don't register FIR. So we know there is a large number of dark figure of crime. The same police, when there is a mandatory requirement that you shall register FIR, they don't used to register FIR. When we give them margin that, okay, you do preliminary inquiry, instead of registering FIR, where the poor Indian will go? So the villagers will be worst sufferer in this situation. And the disservice, first circumstances. Second, 156 clause 3 which was there, that become 175 clause 3. Those who are aware of 176 clause 3, what the system was earlier operating was that if police don't register FIR, a citizen can go to the magistrate, they say the police has not registered FIR, magistrate will direct the police that you registered FIR, investigate the case. Now it says that before directing for FIR, magistrate must hear that police officer. That a police who is not registering FIR, they will ask for call for report. Now when you ask for call for report, if nothing happened, it will kill 10 days time. Suppose a kidnapping case, a family went to the police to register FIR, police is not registering FIR, that family go to the court and the court will say, okay, I will call for report from the magistrate, because without which they cannot direct. Where the poor Indian will go? So it is not really making the things active. That again, this service. Third thing in complaint. But in the morning, someone has raised issue about the pre-cognizance hearing. Now, in the complaint case, someone goes to the court can hear the complainant, hear one or two witnesses to satisfy there is a case is made out or not, prima facie satisfaction, and the court can issue summon. As soon as summon is issued in 204, that means cognizance has been taken. Now under the new law it says, provided that the magistrate shall not take cognizance unless opportunity of being heard given to the accused person. So in one trial we are having second trial, mini trial. Now these three provisions, which basically the way the criminal cases start, we are creating hurdles for the poor Indian, is the biggest disservice which this law has done. So what we were saying, good thing, colonial, etc., it is the disservice which done to the Indians. That's the first thing. Many times we raise the issue. In the morning also someone says about the E-FIRs and the without jurisdictions. What the word E-FIR they said? It says the officer in charge the FIR shall be recorded on, it shall be taken on, the wording is, it shall be taken on record by him is officer in charge, on being signed within 3 days. Impliedly, if you send by email, within 3 days you will go to the police station, you will sign the formal FIR, then FIR number will be done. Is it E-FIR? E-FIR concept should be that if I am filing FIR, there must be system, I will sit in the computer, I have my detailed signature, I will sign there, FIR will be registered. So if before this law, when we used to send email or SMS to the police, the same thing would happen. The police used to call the persons, prepare the hard copy, they sign it. So what was the system earlier? The same thing is there, nothing changes. The way it is being portrayed as E-FIR, that really the things has been, magic has come and the E-FIR is registered. E-FIR in real sense it will become E-FIR when we develop the system where the people can register FIR sitting at their home. That also, I think, some kinds of a misnomer which are being spread, that changes has been done in the law. In that way, there are many things in the law which they have done where they have changes in the provisions. There are some smaller omissions are also there. For example, in section 35 clause 3, Supreme Court categorically says the notice period should be 14 days. There are many cases where court has said that has not been included. So these are the smaller. There are many places there are omissions. In that way, there are another places when it says one of the best thing, okay, that's I said what the worst thing they have done. The best thing BNSS has done is inclusion of section 105, where the police can do, when they do search and seizure, they will do videographies by audio, video, electronic means. Excellent provisions. But where it apply? Why it was included? It was included to avoid any kinds of argument or planting of evidence. So the always issues come that police when do search, etc., there might be a planting of evidence, or at least defense can argue that there was a planting of evidences. So once you have by audio, video, electronic means there is no chances of planting. Excellent provisions. Where it apply? It applied to search and seizure conducted in the chapter of search and seizure, which include 94. So when police ask someone to submit the document, it apply there. It do apply to section 185, 186. So when police do search without warrant or with warrant. But it does not apply to search and seizure which was done after arrest. So when a person is being arrested and his body is searched and some contraband article found, the seizure is being made, it should apply there also. But they have not mentioned that section. Impliedly, we have taken care of planting of evidence when search and seizure done by virtue of search and search warrant or without search and search warrant. But we leave the option open when police do planting when people arrest someone. So we are keeping the options open. While there is judgment of the Calcutta High Court in NDPS cases, the High Court categorically says you must do video recording. So the provision of 105 should also extend to when search and seizure conducted after arrest of the accused person. That's the another gap which exists in the law. 107 most dangerous provision under BNSS. We don't have any much time, otherwise I could have explained the provisions why they have deleted it. 144A they have deleted. I don't think it was a right time to delete 144A CRPC. 172 which they have added again. I suggested for things. One thing which I will suggest all of you, all the students and all the panelists, Government of West Bengal has formed a committee. The committee's details are available on the website. Those who presented today, please send your suggestions to the committee formed by the Government of West Bengal. Whatever you think about the provisions which you want to retain or delete or add and alter till 31st of August, that means another tomorrow, might be they're going to extend also. But you can submit your report to the committee and you can ask them to take some measures so you can contribute in that. Another thing, there are many things which I wanted to discuss, but we don't have that much time. One thing which always I wanted to say is about, we have discussed about the in absentia trial of the proclaimed offender. Now, I just want to share one example. During the British regime, so it was old CRPC, not even 1973 CRPC. In the old CRPC regime, suppose a person is being convicted, he is in jail. In that point of time, there was a practice that if the appeal will be filed through the jail inspectors, etc., in the higher court, in the high court, and as a practice, if the high court will peruse the entire document and they found that appeal has no merit, etc., it will be deemed to be considered as a hearing without giving opportunity of the accused to either present himself in the court or present through lawyer. Now that was the situation pre-independence period. In that point of time, there was a judge called Justice Sayyid Mahmood. He was a Uttar Pradesh judge, so there was a 5 judges in the High Court at that point of time. And that continuous practice was very offended with that. So he given a dissenting opinion in a case called Queen Emperor versus Pohpi. That was the case name, PUHPI. The case was 1891. It's reported in Indian Law Report. In that case, he said that if the accused either himself is not appearing or his lawyer is not appearing in the court, it cannot be considered as hearing. So he said either accused must be given bail or allow from jail to appear his persons. Unless he see them, he will not pass the order. So he said hearing means must be constructive hearing, not only seeing the document. Now, the result was, subsequently he was resigned from the court because after this dissenting opinion, he said, I will not part any order unless I find either accused in my court or I find some representative. So that point of the Chief Justice has started not giving any assignment to him. So these kinds of criminal cases he was not getting thereafter because of his dissenting opinion. He is famously called the dissenting opinion judge of the colonial India. Why? Because the substantive hearing was not given. That judgment was referred to in just recently, few years ago, in a case called Kalwa versus State of Uttarakhand, and it's a 2018 SCC. The reporting is there. Uttarakhand judgment, SCC online. Case name, again I am saying Kalwa versus State of Uttarakhand, where the court has referred to his judgment, dissenting opinion, and says that was correct. We must give opportunity of heart to the accused persons either through himself or through a representative. If he is not appear, it's not a hearing. Court has acquitted the accused, discharged the accused who was convicted by the lower court but has not given effective opportunity to representative. So in colonial India, what practice was there, dissenting judgment has changed it. He attempted to decolonize. Now in modern India, we are colonizing it. We are going back to same system what Britishers was following that point of time. We are starting in absentia trial. How far it is justifiable, I don't know. Particularly in cases where someone is not appear in the case from beginning. So there could be two situations. Someone appear in the court, face the trial, in between jump. He knows about the case. But some accused who never appeared, he doesn't know about the case. Can we conduct in absentia trial? Is it not violative of fair trial principle? What is that? Here the hearing means, what the opportunity means. So it's not only cosmetic hearing, it's not only cosmetic representation, but it must be fair hearing. It must be fair trial. It must be effective representation. So I hope some of the colonial laws which they have done, we should not follow it now. What they have not done, we should not introduce now to create more hurdle for the citizens of this country. Many things which they themselves has not done. In complaint cases, they have not started the procedure. The same thing what was there in the earlier last century CRPC. E-FIR, the similar thing was there. Now we are creating hurdle in the accessing to justice. So you have to decide whether really we have decolonized or we are recolonizing to the old British systems where the Indian citizen was facing difficulty in getting access to justice. Now we got law, we cannot change it. But at least some state is attempting to make some amendment. So be party to it, assist them, suggest them wherever you think it's appropriate. The remaining main provisions are same. So with these few words, I thank to Haldia Law College for inviting me. Due to the paucity of time, I had many things to discuss, but the changes are there. But these are the few points which I wanted. You must know about these provisions, where really, and you decide yourself what we can do. In some places, as the discussion has not been made, I just want to make one more point on the Sakshi Adheniyam. We got amendment in the Sakshi Adheniyam. We got 57, primary evidence, 4 explanations. Excellent, I am not criticizing it. Where the difficulty comes is, along with these, legislature wanted to make it simple. But while making it simple, they have make it more complicated. How they have done it? Now, what the 63 requirements are, there are 2 certificates. Certificate A at the time of seizure, certificate B by the expert. Now, in criminal cases, we can understand police is there, prosecutors are there, systems are there. But same Evidence Act apply, Bharatiya Sakshi Adheniyam apply for civil cases. So suppose husband and wife has a divorce matter where husband has sent message to the wife or wife has sent message to the husband and they have in WhatsApp chat which they have saved in the computer. They wanted to transfer in pen drive. If they want to admit in pen drive, they have to make the same certificate. They have to send this thing to the expert. Now which expert, from where they will get the expert? So we created it, the same standard we have created for criminal cases, the same standard we have created for civil cases. It will create challenge when we try to implement it at the grassroots level. So if rigidly we will apply 63 certificate for civil cases, where is the infrastructure? Who will give the certificate B? Who will file the certificate A? Even I cannot fill up that form because it's required to find out has value. I don't have that software. So if a literate persons cannot do, how can we expect the villagers, etc., they can follow the same procedure and able to admit those digital evidences? So it's a very good foolproof system for maybe criminal cases. But the same law applied to civil cases also. So hope the court can come up with something. Already court has started interpreting. The worst thing they have done is about the last section of both the law, BNSS and BSA. They says for all cases they will apply old law. For new cases they will apply new law. Criminal cases may be disposed of in 20 years. Civil cases may be another 50 years. So we are not getting to get rid of Indian Evidence Act. Now some good sense has prevailed. Now recently, one of the High Court says that some beneficial provision will apply to old cases also. Hope they will interpret and judiciary can pass some order by which they can make these provisions applicable in the old cases so that we can get rid of this difficulty that for one cases we are taking Indian Evidence Act, for other cases we are taking BSA. We need to get rid of this silence. So with these few words, thanks everyone for hearing me. Thank you.
Thank you, sir, for such an invigorating speech. We are at the edge of the segment, which will be concluded by Dr. Pratim Sarkar, Sir, Associate Professor, Haldia Law College, with the delivery of vote of thanks. Please, sir.